So yesterday we looked at the Supreme Court and how it's evolved over time, different significant cases it has taken. And of course, that was what the bell ringer was about. And hopefully, you were able to get through the government 5 crimes determining. You were able to go through the different definitions that are provided of types of crimes, and also the Google form where it asks you to go through and charge people with a crime and then copy and paste a piece of evidence from the scenario that justifies your reasoning. So if you weren't able to get done with that, you'll have time after the notes to work on that as well. So today we're going to talk about in the notes the procedure used in a trial. And some of this might already seem familiar based on how much Law and Order you've watched or some other type of TV show. But first of all, before a trial even happens, obviously, the investigation of the police occurs. The investigation of the police. And of course, they're going to gather evidence, which includes testimony from witnesses. Now, because of some TV shows and movies, a lot of people think, especially when they sit in a jury, that there's all this exact evidence like DNA and other types of things. But often that's not the case. In fact, in many cases, it's just simply witness testimony that occurs. Yes?
I was a witness once. Actually, I was a victim once.
Oh?
And they put me up on stand. I testified. They asked a few questions, and then the accused was charged.
Right. Yes, so they could end up using people that were either the victim or witnessed the situation occurring in the actual trial later on. And you can be subpoenaed, so you can actually be forced to go. Sometimes you don't necessarily have a choice. And they're, of course, going to look at initial suspects, which are often people that are closest to the victim. Crimes are less likely to be committed by strangers. They're more likely to be committed by someone that probably knows the person that suffered the crime. Some people, of course, take that personally when they're asked, but that's just a standard procedure, and statistically, there's a lot of evidence to back that up. There are things that are used in the investigation process that can't be used necessarily in a trial, like lie detectors, for instance. Lie detectors aren't a 100% way to tell if someone's telling the truth. They do provide a lot of evidence, but they aren't necessarily foolproof.
It's a heartbeat thing, right?
Mm-hmm. And there are a lot of other aspects that the police have the ability to collect evidence. They don't necessarily need something like a warrant, for instance, like when people put out their trash or if they leave something out in the open. Those kind of things can be gathered without any type of warrant. But otherwise, the police do have to have a warrant or probable cause to seize any type of evidence from someone's home or other personal property that they might not otherwise give voluntarily. Then, of course, they turn over their information to the district attorney, who is going to decide whether or not to press charges against an individual. If it's a felony case, especially a more severe felony like murder, for instance, the prosecutor will use perhaps a grand jury. And so there's a difference between a grand jury and a trial jury. A grand jury is used before everything happens, really. And a grand jury decides whether or not someone should be charged. Once again, that's for serious crimes. That's not going to be for minor ones. And if the person is arrested, they'll be arraigned. They'll be brought before a judge, and it will be determined if they are a flight risk, if they will flee once released again, or if they should be kept in prison in the meantime. If they're a danger to society, or it's been proven that they are more likely to flee the area. And so if they do decide to let them stay out in the open, then they might have to put forward some kind of bail or financial amount that they will lose if they do end up fleeing. Then, of course, a trial is set. And it can either be a bench trial, which means there's just a judge. And, of course, if it's a crime, then the person has to request that. They have to request that it's only a judge. And otherwise, though, it's going to be with a jury. And so the prosecutor is going to start off the trial with their opening statement. And the opening statement is going to include basically just a summary of everything that they're going to say. They're going to present kind of an abstract or summary of what they're going to present throughout the entire case. The prosecutor will go first, and then the defense attorney will go second. And then we'll go through the examination period. And that is when first the prosecutor, then the defense will put forward all of their evidence to back up their position. And of course, that can be direct evidence, so it can be witnesses and forensics or confession. You often hear the word circumstantial. That is opinion based, with no physical proof. And while both sides are giving their presentation, the other side has the ability to object to the things that they do. For instance, if the attorney tries to lead the witness in a certain direction, instead of just asking questions, they're making statements instead and trying to lead them in a certain direction. The opposing attorney might object to that, for instance. And it's up to the judge to act as a referee. So they'll either sustain their objection, which means they agree with it, or they'll overrule it, which means they don't agree with their objection. And both sides are allowed to cross-examine the other person's witnesses. So the prosecutor brings up a witness for them. After they're done, the defense is allowed to cross-examine or ask them questions as well. That, of course, is included in the Sixth Amendment. And, of course, witnesses can be treated as hostile if they're not being forthcoming. The attorneys can take a more direct stance with them when asking questions. And then the conclusion. Both sides will give a closing argument, which is once again just another summary of what all the trial is about. It's going to be different, though, because both attorneys are going to watch the jury and their reactions to certain evidence or witnesses, so they're going to change a little bit, perhaps, their closing statement, so that's why it's not the same as the opening. The judge is going to give the jury their duty, which is to, of course, decide whether or not the specific charges match the crime that was presented, and decide whether or not the person is guilty or not guilty. If they do decide they're guilty, it has to be beyond a reasonable doubt. In most states, in a criminal case, the ruling has to be unanimous. In other words, they all have to go together one way or the other. That's not true in a lawsuit, though. In a lawsuit, it's just a simple majority. So when someone's suing another person. The jury might be sequestered or asked to stay overnight if they haven't come to a conclusion. Or if it's a controversial case where the judge doesn't want them to be influenced by the public, they might be sequestered during the entire trial. That's unusual. If no decision is made, then it's referred to as a hung jury. A hung jury. If that occurs or anything else that messes up the trial, it's referred to as a mistrial. So if a hung jury or anything else happens that messes this up, it's referred to as a mistrial. And when that happens, it means the prosecutor has the ability to start the trial all over again with a new jury. There's one case, this has been happening over the last couple of years. There's a guy brought to trial 5 different times. Each time there was a mistrial.
What did he accused of?
I don't recall. I don't think it was murder. So, after this is all done, of course, then it is up to the court to decide if that person has been found guilty, what type of punishment they should receive. And of course, that depends on the type of crime they committed. And we'll talk more about that tomorrow. So for the remainder of today, you can finish up that crimes determining activity or the government 5 reading, or you can work ahead if you'd like to as well.